All right, everyone, I'm going to get us started. We have two clocks on slightly different times, so choose the one that you prefer. I'm Susanna Baruch. I'm the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. Welcome to this exciting book event. I am going to just briefly thank a few folks who made this possible. Our team, Lisa Gorelick and Laura Chong, who I think are outside, without whom none of this would be possible. This event is also co-sponsored by the Institute to End Mass Incarceration at Harvard Law School and the Malcolm Weiner Center for Social Policy program in Criminal Justice Policy and Management at Harvard Kennedy School. And it is also made possible with support from the Oswald D.N. Kamen Fund and the SciSafe Foundation, Tim Ferriss and Matt Mullenweg. The real introduction here is to hand this over to Mason Marks, our moderator. He is the Florida Bar Health Law Section Professor at Florida State University College of Law. He is also the Senior Fellow and lead of Petrie-Flom's project on psychedelics law and regulation. So with that, Mason, it's all up to you.
Thank you so much, Susanna, and welcome everyone. Thank you for joining us. Drug law and policy have always been around, but it does sort of feel like they're having a moment right now. We had two presidential candidates, both endorsing some form of marijuana policy reform, and psychedelic medicines even made an appearance during the election. So there seems to be kind of something happening, not sure exactly what, but there is something happening. But it's very timely that we're discussing this new and exciting book by David Pozen, The Constitution of the War on Drugs, published recently by Oxford University Press. And the amazing thing about this book is that it's open source, so you can download it for free on ssrn.com, which is incredible. I'm going to get right to David so he can tell us about the book, and then we'll have some comments from Jeannie Gersen. David is the Charles Keller Beekman Professor of Law at Columbia Law School, where he teaches constitutional law, drugs and the law, and nonprofit law and policy. And there's a small group of law faculty that I think is really modernizing the field that I call drug law, really making it current. And I think David is one of the people that's really doing that, and his book is truly a landmark in this very dynamic, emerging, and important field. And again, I said we're very fortunate to have Jeannie Gersen with us, who is the John H. Watson Jr. Professor of Law here at Harvard Law School, where she has taught constitutional law, criminal law and procedure, family law, and the law of art, fashion, and the performing arts. And she's also a founding faculty member of the Petrie-Flom Center's project on psychedelics law and regulation, or POPLAR. So I will just, without further ado, I will turn things over to David to hear some comments about his great new book. Thank you for joining us.
Thanks so much. I want to thank Susanna and Glenn for inviting me, Mason and Jeannie for commenting on the book. It's really an honor to have such distinguished scholars here. Thank you for coming out on this dreary day. And I especially want to thank in the audience my mother for joining us today. So I will try to summarize the book in 15 to 20 minutes before we get into questions. I'll say a little bit about what drew me to the project and then what the book covers, and then look forward to the conversation. So the book is a critical constitutional history of challenges to punitive drug laws. And it recovers this period of possibility, especially in the 1960s and 1970s, when it was unclear whether constitutional law would curb what would come to be seen as the worst excesses of the war on drugs and punitive prohibitory policies generally. Before getting into that story, I'll just say that I was drawn to this project in part by an absence. That is, the absence of the Constitution in our conversations today about drug policy. And I find it really interesting and puzzling that drug reform groups today almost never enlist the Constitution in their attacks on criminal drug laws. Puzzling for a number of reasons. One is some of the central themes or tropes of the contemporary drug reform movement include things like individual liberty, racial equality, and rational government decision-making. And these are some of the central tropes of modern constitutional law as well. So these groups are, in a sense, speaking the language of common law without actually invoking the Constitution. I found that strange. In addition, I knew enough about US constitutional drug-related history to know that in prior generations, we've had fierce fights over the constitutionality of drug prohibitions. So historically, it's a bit puzzling that those have faded into obscurity. And most constitutional scholars, I find, aren't even aware of that history. Third, abroad, there is a movement to constitutionalize protections for drug possession and consumption well underway around much of the world. Courts in Latin America took the lead, but it's spread across Europe, parts of Africa and Asia as well now. So the US, in a sense, birthed the idea of constitutional drug rights in prior generations, but has now fallen behind much of the rest of the world in this area. So how did that happen? And then finally, the US is a constitutional culture in which we are often said by people abroad that we're a country that constitutionalizes every social dispute, whether it's reproductive rights or gun control or affirmative action in higher education. Everything seems to end up in the courts here and get rendered as a constitutional fight, and yet not drugs. So how did drugs get deconstitutionalized in this culture and when we tend to constitutionalize everything else? All right, so all of this made me think that there's something interesting to explore here. To the extent we do talk about the Constitution with respect to drug policy today, it tends to be about enforcement, ways in which the drug laws are enforced by police and prosecutors, and often we have Fourth Amendment debates about when police tactics go too far, whether it's stop and frisk or aerial surveillance or racial profiling. We have fights over the enforcement of drug laws, which are, of course, extremely important. But the book tries to argue that, in a sense, those fights are downstream from the first order question, which is when and under what conditions can the government prohibit and penalize drug behaviors in the first place? And in the 1960s and 70s, the period the book focuses on, you have all these government commissions and scholars recognizing quite clearly that if you allow the government to criminally prohibit popular drug behaviors, you're going to get extremely intrusive and invasive and racialized police tactics. Because how else are you going to enforce those laws when two people sell, when someone sells drugs to another person, that's a voluntary transaction. There's no victim who's going to report that crime. Drugs are small and portable, used in the home often, so the police are going to have to be very aggressive, and given the political and racial economy of law enforcement in this country, likely going to do things that run up against not only Fourth Amendment concerns, but also racial equality concerns if they're going to enforce these laws. So all of which is to say, I think the more fundamental question before we get to enforcement is again, under what conditions can the government criminalize drug behaviors? So the book takes us back to this period of possibility when leading establishment groups, including the American Bar Association, the American Medical Association, the Consumers Union, the National Council on Churches, the National Council on Rabbis, were all in the late 60s and 1970s calling for various kinds of drug decriminalization or liberalization. You have President Carter expressing openness to marijuana decriminalization, if not cocaine as well. President Ford carried that forward to some extent too. And this kind of political ferment around drug policy was matched in the courts by active litigation and contestation over drug prohibition. And the book walks through all of the different parts of the Constitution that were enlisted in the struggle to rein in the harshest drug laws. So maybe I'll spend a few minutes just explaining which parts of the Constitution were litigated and what happened before closing out and entering into the commentary and questions. So in all of these areas I'm going to describe, litigants won some victories, usually in the state courts or the lower federal courts in the early 1970s in particular, showing that it really was plausible that we would get constitutional protection for some drug behaviors before eventually the doctrine turned against this movement, so that by the time we got to the 80s and drug enforcement and drug policy becomes much more draconian and enforcement becomes militarized, before we get there, the doctrinal fight is essentially over. So in other words, I want to suggest that in the 1960s and 70s, we could have nipped in the bud what would become the monstrous war on drugs by the 1980s and subsequently, when the courts were more receptive to this set of arguments, and then for a complicated set of reasons we'll get into, didn't quite work out. Okay, so one set of arguments that were pressed vigorously in this period had to do with privacy and liberty. In 1965, the Supreme Court in Griswold versus Connecticut, as many of you will know, recognizes a right to privacy for the first time. Initially, it's unclear where it's going to be housed. It ends up in the Due Process Clause. The court says in that case that particularly when the conduct at issue doesn't cause any direct harm to others, and when it's in the home, you have a especially strong case for privacy protection. Drug lawyers immediately recognize that Griswold is a resource to challenge drug prohibitions that extend into the home. And you have lots and lots of cases taking up privacy and liberty claims on behalf of drug rights, particularly with regard to marijuana. Several state Supreme Courts accept versions of these claims, most famously the Alaska Supreme Court in a case called Raven versus State in 1975, finds that Alaskans have a right to the personal use and possession of small amounts of marijuana in the home. That Raven remains good law in Alaska and has been very influential in courts abroad. However, by the end of the 1970s, the federal appellate courts turned back this tide of privacy and liberty claims for drug rights. And the key move that they make to do so is to establish that to have any chance of winning on a substantive due process, liberty or privacy claim, you first have to establish at the threshold that the liberty or privacy interest you're seeking to have vindicated is fundamental. And only if you have a fundamental liberty or privacy interest that's been abridged can you get meaningful judicial review and not just rational basis review. And this proves fatal to the drug rights movement in this area because no litigants are able to convince judges that smoking pot or what have you is fundamental. What the Alaska Supreme Court does in Raven that allows them to reach a different ruling, and what courts abroad have increasingly been doing, is not to ask whether the liberty or privacy interest is fundamental before engaging in meaningful review, but to do a kind of balancing and to ask, is there any liberty or privacy interest at stake here? Yes, there is. Individual freedom and autonomy are implicated by personal drug use to some extent. But then the court asked, but what's the interest on the other side? What is the government's interest in criminally prohibiting this behavior? And that's really the weakness of a lot of these drug prohibitions, not necessarily that some paramount autonomy value is at stake, so much as that the government interest in criminalization is very weak, and indeed often those policies are counterproductive. And so once the federal courts clarify that they're not going to evaluate substantive due process claims in that fashion, but rather going to focus on fundamentality, that line of cases dries up. Other cases ask about government rationality. So there was a set of mid-century cases under the Equal Protection Clause that said when the government is drawing criminal classifications, criminalizing some behaviors but not others, those classifications always have to be tested for rationality, for the reasonableness of the distinctions they draw by the courts. And again, the marijuana lawyers came into court and said, there's an abundance of evidence that marijuana is less dangerous and less addictive than other drugs in the same statutory schedule. Marijuana at the time was lumped with heavy narcotics in the most restrictive drug schedules, as it still is at the federal level. Meanwhile, tobacco and alcohol, known to be significantly more dangerous drugs, aren't scheduled at all, are legal. And this is so fundamentally illogical, the way in which cannabis is being treated, that it violates equal protection. And this may seem surprising now for those who learn that rational basis review is toothless under equal protection review. But I collect about 12 cases from this period where courts at different levels find that cannabis's classification as or with heavy narcotics is so illogical that it violates equal protection. And then again, however, the courts ultimately pull back from this line of rulings on the logic that courts aren't particularly competent at rendering decisions on just how dangerous different substances are, that if there's any amount of uncertainty or dispute about how dangerous a substance is, courts should just defer to what the government has chosen. And so the kind of the way in which rational basis review would come to be a rubber stamp outside of protected categories really plays out in the drug cases in this period. It's in the drug cases as much as anywhere that the courts fall back on this toothless form of rational basis review and ultimately uphold marijuana's placement in dubious drug schedules. I'll be quick on all of these and can go into more depth if there's interest. When it comes to the more familiar set of equal protection claims around race discrimination, interestingly, these aren't heavily litigated in the 1960s and 70s, even though the doctrine is actually pretty favorable to such claims at the time. It's really only when you have the differential treatment of crack versus powder cocaine in the mid to late 1980s, with a clear racial valence and a profound racial skew in who's getting prosecuted under those laws, that race-based discrimination claims come to the fore in court. And you have lots of litigants coming into court then and saying that this violates equal protection, the way that the white-coded version of the same substance is penalized so much less harshly than the version that was coded black at the time. And there, too, you have a small number of judges recognizing the force of that claim, finding ways to work within equal protection doctrine to vindicate it. But by that point, the courts had already decided that you needed to establish, in the absence of a race-based classification on the face of the law, an intention to discriminate, the discriminatory intent as a part of the reason that the law was adopted in the first place. And litigants were unable to convince the federal appellate courts that the crack powder disparity was created because of a desire to subordinate any particular racial group, even though it was having that effect in practice. I'll shift now to the Eighth Amendment set of arguments in this period. In some ways, these were the most robust set of cases and yielded the most victories before they too got rolled back. There are actually two different lines of arguments that were pressed in the 1960s and 70s about how punitive drug laws could violate the guarantee against cruel and unusual punishment in the Eighth Amendment. One set of cases focused on drug addiction. And in 1962, in a landmark case, Robinson versus California, the Supreme Court held that a state law that criminalized the status of being a drug addict was cruel and unusual punishment. After that ruling, a lot of lower courts quickly wrestled with whether, if it's impermissible to criminalize someone for being an addict, it should likewise be impermissible for criminalizing them for doing things incident to their addiction, like buying and using the drug to which they're addicted. And you have a number of rulings going in that direction until the appellate courts pull back on that by the early 1970s. And then a separate line of cruel and unusual punishment challenges were, in a sense, even simpler. They argued that sometimes when the punishment so profoundly doesn't fit the crime, when there's this gross disproportionality between the moral gravity of the offense and the severity of the sentence, that can be cruel and unusual. And the Supreme Court had blessed that basic way of reasoning by the 1970s. And you have a number of courts finding that long prison sentences for nonviolent, non-trafficking drug offenders were just grossly disproportionate to the moral gravity of the offense. But there too, we have a rollback by the end of the 1970s, the early 80s, where the Supreme Court clarifies that basically when you don't have a death sentence, which is very rare in drug cases, then courts should almost never find gross disproportionality. And so those cases dry up right before the prison population explodes, in no small part thanks to the war on drugs in the 1980s. And then finally, the First Amendment gets litigated extensively in this period as well, both the Free Exercise Clause and the Free Speech Clause, more so the former. There's a landmark decision out of California in 1964 in a case called People versus Woody, where the California Supreme Court rules that the Native American church must be allowed to use peyote for their religious rituals, even though it's otherwise banned, and that otherwise their free exercise rights would be violated. After that case comes down, every drug defendant starts to come into court with a woody defense. I'm using this drug because it's important to me spiritually or sacramentally as well. I'm part of a drug-based religion as well. And courts quickly get afraid that the woody logic is going to spread everywhere, and basically confine that set of free exercise rulings to the Native American church and peyote. It's since been extended to a few other groups as well, but it remains quite limited in the groups that have won under religious liberty claims, first under the Free Exercise Clause, now under the Religious Freedom Restoration Act or its state analogs. The Free Speech Clause may seem less intuitive to you. What's that doing in a book about drugs? But there are two lines of free speech arguments that were also litigated. The less successful and I think kind of less plausible version was the claim that drug use itself amounts to a form of political speech or symbolic speech. That is, people sometimes use drugs to make an anti-establishmentarian or anti-war set of statements. And therefore, their drug use should be recognized as a kind of political expression. The courts were not really interested in that argument, thinking that if that's right, then many things we do might be protected expression as well. The main reason people use drugs is presumably not to make a political statement so much as for pleasure or the like. But more interesting, I think, and actually more alive today in the academic literature, especially abroad, is the freedom of thought version of the claim. So this argument said that a long line of 20th century cases had held that as a component of or corollary to your free speech rights, you must also have freedom of thought, and that governmental efforts at thought control are impermissible under the free speech guarantee. And it was a staple of drug culture at the time that drugs can free your mind, as the Beatles said, or open doors of perception, as Aldous Huxley says, and therefore that certain types of government drug prohibitions, particularly with regard to psychedelics, amount to an attempt at government thought control, preventing you from receiving inputs that might affect your cognition or sensation. And this didn't go very far in the courts, I think it's fair to say. Larry Tribe, here from Harvard Law School, in the 1978 edition of his renowned common law treatise, suggests, however, that this looks like a strong argument in principle, that certain drug prohibitions would amount to thought control, impermissible under the First Amendment. And again, now there's the pretty robust literature on what's sometimes termed cognitive liberty, the cognitive liberty case for drug access, which Mason has contributed significantly to. It's just to say that if it might strike you as fanciful that the Constitution would have anything to say about drug policy, the book tries to show that many different parts of the Constitution were not only thought to speak to punitive drug policies, but actually scored victories in this period in a number of courts in reining in extreme drug policies. And I won't say much more about where the book goes at the end, except to note that although most of those types of arguments I just summarized are not viable still, the doctrinal pathways are closed in light of the precedents that accrued in the late 70s and 80s, shutting them down. I do think there still remains any number of possibilities for drug reformers today to enlist the Constitution. At the end of the book, I talk about how originalism, the ascended interpretive methodology on the court today, surprisingly offers a number of different moves that could be made to attack certain drug policies. I won't get into detail now, but just to say, for example, that there's quite good original scholarship on how the original understanding of the Cruel and Unusual Punishment Clause in 1791 was much more expansive than what the court recognizes today for nonviolent offenses, and could be straightforwardly applied to rein in long drug prison terms. But then I also talk about how we could do what the rest of the world has done, which is do a kind of structured balancing, often known as proportionality review, looking at the liberty, autonomy, privacy, or what have you rights on the one hand versus the government's case for criminalization on the other. And that has been used very effectively to promote kinds of decriminalization abroad. I see the US state Supreme Courts as much more interested in that style of review than the federal courts, and suggest that there are avenues there. And finally, and I'll end on this note, I think constitutional law can and should do significant work outside of the courts when it comes to drug policy. Courts are inherently limited in what they can do with regard to drug policy. I think they can serve as a brake on over-punishment, but they can't craft forward-looking policies in any robust way. That's going to have to fall to legislators and regulators. I think it's a scandal that the Department of Justice and Health and Human Services and Congress don't take constitutional considerations into account whatsoever when formulating drug policies. And all of the constitutional values that are implicated by punitive drug policies that the book canvasses, I think ought to bear on what the political officials do when they're deciding how to schedule marijuana, say, a debate right now, or psychedelics, or any other aspect of drug policy. So even if the courts aren't going to take the lead in this area as it once seemed they might, I still think there's a lot to learn from this constitutional history to inform a less punitive, less prohibitory set of drug policies that would also likely be more effective, if not in the courts, then in the political arena. So let me leave it there, and thank you again for having me.
Wonderful, thank you. And we'll turn to Jeannie Gersen for some discussion.
Thank you. Thank you so much for coming. I really love the book. And for all of you who've taken constitutional law or will take constitutional law, this really is a book that, yes, it's about the war on drugs, but it's also a book that if you put, it's like putting on a pair of glasses and you can see the field of constitutional law, the entire field, through those lenses in a way that's incredibly illuminating. So I really thank you so much for writing this. And thank you to Dave's mom for coming. And I take it you live in town, so if you can help us recruit him to come here permanently, that would be wonderful. So I was wondering if you were gonna mention one of my favorite lines in the book, where you recount at some point, maybe in the 1970s, one of your colleagues was teaching a class on this very topic and was having a very serious discussion with the students about whether the experience of tripping on psychedelics could be covered by the right to travel. So, but this brings us to the idea of rights, drug rights. That's just not a phrase that we've encountered. You've all taken, some of you have taken constitutional law, like we've talked about all kinds of rights. We've talked about abortion rights, the right against discrimination, Eighth Amendment rights, First Amendment rights, but the word drug rights just doesn't have quite the ring to it. And you're explaining how that was not an accident and it came about for a reason. I want to just approach the topic a little bit, maybe in a way that others here would not, mainly because of my teaching as a constitutional law professor and as a family law professor. So the first case you mentioned in this presentation was Griswold versus Connecticut, which was, if you'll remember, it was about contraceptives, the use of contraceptives in the home, in the bedroom, and Justice Douglas, famously is just horrified at the idea of the police searching the inner sanctum of the marital bedroom for telltale signs of contraceptives. And that's the beyond imagining. We can't have a society where that is allowed, right? And that's the rhetorical force. And it's not just rhetoric. There really was a very strong tradition that he was drawing on, that the idea of marital homes, the idea of what happens in the privacy of a marital couple and the space that they create, almost like a sacred space that had to do with the religious overtones of the marital relationship. And that kind of marital privacy became the basis for the right to abortion, because when we get to Roe versus Wade, you're going to see, of course, that there's the idea of the woman who needs an abortion, maybe because she's a single woman, not married, and so the whole paradigm of marriage becomes very central to how we think about constitutional privacy in the substantive due process context. And it really made me think about a couple things. One, a few years ago, a really good friend who is a writer in this area, very important writer in this area, graduate of this law school, told me that taking ecstasy with her husband was among the best marital, spiritual relationships, much better than years of couples therapy that she could possibly imagine. And so she thought of this as a really central part of the care that goes into a marital relationship, and the couples, sort of, it's almost like, akin or kind of adjacent to sexual relationship, that the MDMA or the ecstasy would be, aiding in the spiritual connection between a marital couple. And she really thought of this as very, very important. And it made me understand maybe that part of what Justice Douglas was horrified by, that you'd be interfering in the marital relationship by going, what, are they using contraceptives? That's a crime. That if we had thought, if somehow drugs had been associated with that kind of spirituality, not just the individual spirituality, but the relational spirituality between a set of people who our system and our tradition thinks of as sanctified in that way, then things might have gone in a different direction, because you don't think of a fundamental right to use contraceptives. You think of a fundamental right to marriage and to, that kind of relationship. And you don't think of a fundamental right necessarily to abortion. You think of a fundamental right to the privacy of a person's, autonomy. And in our constitutional law, it came about because of the idea, it came from contraceptions in a marital relationship, and then it kind of moved over kind of as a metonym almost to, bodily autonomy of women. And so that's one thing I wanted to raise, mainly because when you think about the temperance movement and the feminist, action, the activism that feminists were very central in saying alcohol was a real problem, right? What they were thinking about is that, people weren't so concerned about women being beaten at home, right, in the privacy of the home. And again, the sort of the umbrella of privacy was not something that women for a very long time thought was a positive thing for them. That libertarian impulse to protect the home was something that the feminist movement, the legal movement, fought a long time, especially in the 1970s and 80s, to be able to say, we need to rethink this. Like, privacy is not a good thing when it comes to gender equality. And the role that played in the encouragement to crack down on alcohol. So I wanted to mention that because the domestic violence movement coincided with the war on drugs, like temporarily, right? The feminist movement to incarcerate people for violence against women temporarily came at the same time. And as our colleague at Colorado, I think she's now in California, Aya Gruber has shown, a significant portion of mass incarceration did have to do with incarcerating people who were for violent crimes and mainly for violence against women, right? So it was not only the war on drugs, it was also significantly the war on violence against women. And so that kind of overlap between the violence against women, the temperance movement, the sort of we want to be harsh on drugs and make sure that people, because the externalities of these substances, the negative externalities are disproportionately on a certain population. Obviously, mass incarceration disproportionately affects a certain population as well. But that interaction, I thought, would be interesting to ask you about, and just how you thought of that. There's going to be so many things I want to get to, but I'm going to get to a few, and then maybe I won't get to everything. The one thing I wanted to raise was just going back to that 1968 moment, the sex, drugs, and rock and roll. And I think in the book you do a great job of showing how the sex part kind of got liberalized, and the rock and roll part did too, presumably. But the drugs part was the one that had the potential in 1968 and in a few years later, but then it didn't. And it goes back to what we think rights are, and liberal legalism, the language of rights that developed. And what do we mainly think you have a right to? Mainly you have a right to something, people not doing things to you or the government not doing things to you, right? You don't have a right to something positive in our American system. And you point out that the phrase in the Declaration of Independence, life, liberty, and pursuit of happiness. Life, okay, people shouldn't take away your life. I mean, unless they give you due process. They shouldn't take away your liberty, again, unless they give you due process first. But then the pursuit of happiness is one that's like dropped out of our legal discourse because we don't think of our having a right to the pursuit of happiness. That's just not something we think of as a right. Maybe other systems do, but the pursuit of happiness or happiness is just something you can create for yourself, but the government is not entitled to do stuff to help you pursue your happiness. And I think what you're getting at here is drugs kind of fits into that box of like pleasure and self-fulfillment in a way that's not just a negative, like leave me alone, right? It's like give me the right to fulfill my own, spiritual imperatives or to pursue what I think of as going to give me pleasure. And then it fits along with this whole category of things we call vice. I used to teach a course on vice, and it involves drug laws, it involved prostitution, gambling, alcohol, that whole thing. And all of those things were ones that, people on one hand thought, well, this doesn't cause harm to anyone else. You're just regulating because you think it's immoral. There's no harm principle that's driving these laws, like the way you would, make a law against murder or assault or robbery, right? So these are laws that are made for moral reasons only, not because they have, harm on other people. But on the other hand, the idea that, why do people do these things? Why do they want to do these things? It was because, we associate the things they do, the immorality, with the kind of like carnal pleasure or the pleasure of the body or the pleasure, of being dissolute or, not doing things that are like orderly and, having a job and, keeping up with your obligations as a citizen. And that's kind of how we think of it. And all those vice laws, they've gone through some, reform as well. But drugs have only gotten, that's only gotten harsher over time with a few little blips where we think that we're going to deregulate. And so I just think maybe the whole idea of pursuit of happiness, because drugs fell under that umbrella, we started to think about it, and we didn't think to put drugs under the liberty umbrella. Doug Ginsburg, is that a name that's familiar to any of you? Douglas Ginsburg. Some of you? Yeah, well, for my generation and maybe those a little bit older, that's a name that's emblazoned on our minds. It's a federal judge who, DC Circuit judge, who did not get a Supreme Court position because it came out that he had smoked marijuana while he was a professor at Yale Law School. Oh, it was Harvard Law School, right, Harvard Law School. Like he was a professor, like a full-grown man, and he had smoked marijuana, and it came out during his nomination, and as a result, he did not become a Supreme Court justice. Now, what did that do? That had the effect, and then a few years later, Bill Clinton, it came out that he smoked marijuana, and you know what he said? I didn't inhale, right? So, okay, here that is, okay, what do you think that does to the generation of lawyers? You're a little younger than me, but like generation of lawyers who going to college and law school in the 90s and, are thinking they need to get jobs in the government and maybe they will be professors someday or, none of us, we are drug virgins, all of us. I'm telling, like our entire generation. We have not ingested, we definitely didn't inhale. We definitely left the room if we saw that there was true story, party, someone had cocaine. My co-clerk came to me and said, Jeannie, we're getting out of here. And we got out of there, So I wanted to, maybe put that to you in terms of, that also contributes to the, cohort of people who are in the courts, cohort of people who are lawyers, arguing cases, populating the entire legal system. And it has an effect. So I think this generation may be a little different. I know you get the talk at the beginning of the year about how drugs are illegal and that you might have to go through like background checks someday. I know you get all that, but things may, as you said, things may be shifting. When my name was associated with Mason's program and at POPLAR, I got like a huge volume of emails, like more than any other sort of one event at Harvard Law School, of emails from lawyers, emails from people just being like, how can I help? Please let me help, to try to do something about the regulation, especially of psychedelics. So we are in a moment where this book is incredibly timely, and not so much because of cocaine and other heroin and other things like that, but mainly because of this drug that's been around for a while, but is having a kind of renaissance in people's renewal of interest. And so, yeah, those are the main things. But I have so much more, and I'll share it with you afterwards.
Supreme Court justices like beer, not marijuana.
Yeah.
Should I respond?
Sure.
Maybe for a few minutes. Yeah.
I'll give. Thank you so much. Those are wonderful comments, and I too could speak at great length about them. So I'll try to restrain myself and just say a few things. I also love the argument that the right to travel encompasses the right to leave one state of consciousness to enter another. And it was, I don't say this in the book, I was a little coy, but it was my colleague who was happy to be identified, Harold Edgar, teaching that seminar with Bob Cover, the famous Bob Cover of Nomos, a Narrative, who apparently was very interested in that argument, though. No court has accepted that the right to travel covers the right to trip. There are many, many parallels, I think, between illicit sex, illicit drug use, and sex regulation and drug regulation, as was evident to people in the late 60s and early 70s. So when Griswold comes down, it's very unclear what it stands for. Is it just a protection for married couples? Is it just about contraception? Is it just about the home? And what gets clarified in the years that follow is it's not limited in any of those regards. It extends, the right to privacy extends to other aspects of control of one's body and important life decisions, even if one is unmarried, even beyond the home. And it leads in turn eventually to Roe versus Wade. In case you think it's a real reach to think that Roe versus Wade would have anything to do with decisions about drug use, the California Senate convenes a special committee in 1974 to study marijuana. And they conclude that Roe versus Wade compels, that was their verb, compels the conclusion that there's a right to smoke pot. So that which I think probably wouldn't, most people wouldn't make that association now. But at the time, again, it seemed like a plausible inference from where the privacy jurisprudence was going. The question of the pursuit of pleasure or happiness is one that is kind of woven throughout the book. And this is, I think, a fascinating story. So the Declaration of Independence, of course, talks about a right to the pursuit of happiness. That language doesn't make it into the federal constitution, but fully 2/3 of the state constitutions have a codified right to the pursuit of happiness in them. And at the federal level, the right to pursuit of happiness was in prior periods understood to potentially inform the interpretation of various clauses. What happens over the course of the 20th century is the right to the pursuit of happiness is basically erased from our constitutional tradition, in part in the drug cases. It becomes associated with vice and with kind of base pleasures, and judges are afraid to operationalize it. And so the right to the pursuit of happiness is basically inoperative at the state and federal level now. And that's, I think, a loss. Constitutionally, I think the right to the pursuit of happiness, at least at the state level where it's codified, ought to bear on drug policy because, of course, people use drugs in part for personal pleasure. You mentioned couples pleasure, communal pleasure, both in a kind of visceral, hedonic sense, and sometimes in a more spiritual or eudaimonic sense. So the pursuit of pleasure could be part of how you litigate drug rights. But even more simply, I think, at the administrative law level, when decisions are being made about how to schedule or classify different drugs. I find it shocking almost that the pleasure, let's call it, the benefits that people feel they experience from drug use are discounted to zero. They're given zero weight in the calculus of how to schedule different drugs. And this is anomalous in administrative law, which increasingly, when making regulatory decisions, takes into account hedonic benefits. They're hard to quantify, but there are methodologies for doing so. And when we're considering, what should the pollution threshold be for trucks on the highway, or whatever it is, the agencies take into account the benefits that people think they receive from the regulated conduct, as well as the costs. Only in the drug space do we basically just do CBA without the B. So we look at the risks associated with drugs. Medical use is also counted to some extent. But the actual reason why most people use drugs, something to do with pleasure, that's called or happiness, falls out of the picture altogether. My favorite little passage from the book, not my own prose, is the last time that the DEA was asked to consider rescheduling marijuana, they had to get an analysis from HHS about the medical literature on marijuana's effects. This was in the mid-2010s. And when you read the final order from the DEA rejecting the petition to reschedule marijuana, as they always have previously, they first recount the scientific evidence on marijuana as HHS gave it to them. And you start reading, and it sounds like a celebration of pot. It says, among the most common subjective experiences reported by marijuana users include merriment, sociability, talkativeness, exhilaration at high doses, increased enjoyment of art, music, food, and sex, creativity, and it goes on, and you think they're like building up a case for these are all the benefits of this drug, but now we have to weigh them against the risk. To the contrary, what they're doing is saying, for all of these reasons, this drug has high abuse potential. It's so enjoyable to so many people that we have to keep it in Schedule I in a total criminal prohibition, because otherwise people might be seduced. The other interesting things I'll say about marijuana, and then a little bit on Douglas Ginsburg, then I should stop, is you mentioned how alcohol, the feminist movement was in part behind the pushing for alcohol prohibition in the early 1900s, given its association with male violence. The one interesting feature, this doesn't make it into the book very much, of the fights over marijuana in the 1960s and 70s, which is the main drug litigated in these cases, is the support it gets from the feminist movement, as in some sense the anti-alcohol, because it has...
People fall asleep?
It doesn't, yeah. But, well, okay, so the Nixon administration pushed the amotivational syndrome theory that made you like a couch potato, but that never really had great support. But it was, as that line reflected, it's not a spur to violence. There's no association. In fact, there's a negative relationship between marijuana consumption and physical violence. So it didn't have that anti-feminist kind of menace. And then nor is it an aphrodisiac, actually, although thought by some to increase enjoyment of sex. So there was a sense in which the drugs are actually being foregrounded in this period, flipped this feminist story, and you can make a kind of pro-intimacy, pro-feminist case for the legalization or decriminalization of at least some of these drugs. As for drugs that do risk these third-party harms, as with violence, I think that absolutely should bear on the constitutional regulatory calculus, against whatever liberty, privacy, or other interests might be on the other side. Finally, Douglas Ginsburg, he's here. Apparently, it's reported by NPR, then others, that he smoked pot, including, I think, with students here at Harvard Law School at one point.
That checks out.
Yeah. And the book suggests this was a kind of inflection point, where in 1987, this undeniably distinguished, credentialed, well-pedigreed DC Circuit judge, former Harvard Law School professor, is nominated to the Supreme Court. And it's revealed that he smoked pot while he was a professor here. And then one thing I hadn't known before I began the research on the book is in the first few days after that revelation came out, it wasn't clear that he was going to go down. There were polls conducted quickly by a number of media organizations which showed a significant majority of Americans saying it wasn't a big deal. His pot smoking should not disqualify him. President Reagan initially stands by Ginsburg and says, he's not an addict or anything of that kind. And it looks like we're actually maybe going to get more nuanced conversation about which kinds of drug behaviors are or are not consistent with mature professionalism, and maybe also recognition that pot isn't so bad as compared to other drugs. But basically, by the end of the week, Reagan pivots back to a hard, he's reminded that his official stance is just say no to everything, and this would be grossly inconsistent with that messaging, and abandons Ginsburg. But that was the moment when I think we could have tipped in a different direction, and was a lost opportunity. I'll leave it there. Thank you for this really rich comment.
Let's take some questions from the audience.
Hello, thank you. This is so interesting. I have a question. So in Massachusetts, we have Commonwealth v. Eldred, which I'm sure you're familiar with, the 2018 opinion, which came before the court the question of whether it is a violation of the Mass Constitution and a violation of the Eighth Amendment to require a probationer to remain drug-free. And it really centered on this question of voluntariness. And a number of medical professional organizations indicated that this was not, substance use disorder was not a voluntary condition. And a couple other organizations said that it was, and ultimately the court decided that it was not a violation of the Mass Constitution or the Eighth Amendment to require someone who has a substance use disorder to remain drug-free. And I'm just wondering, within the context of evolving neuroscience, where we now know that you can look at a fetus and look at D2 receptor availability in the striatum and predict who is very likely to go on to develop a substance use disorder, if the issue of voluntariness is at all sort of implicated in any of this.
Great, thank you. It's a deep question. I think it is, but this is really what got shut down by the court in the aftermath of Robinson in the late 60s. So. Actually, in Robinson itself, that's the case in which this California law, as the federal courts had construed it, made it a crime to have the status of being an addict, and the court said that's cruel and unusual categorically. And then all these questions arose. Well, what if you do things pursuant to your addiction? Insofar as the logic of Robinson was, you shouldn't be punished for behaviors that are in some sense voluntary. And in fact, in Robinson, the majority opinion invokes the concept of born addicts, a phrase that had been used in a popular Time magazine article some years before, to show how wrong it was to think that someone should be subject to criminal punishment just for being an addict. The point was some people can't help it. They get medication for an illness or a surgery, they become addicted, they're born into addiction, or they start using voluntarily, but then it becomes involuntary. And then there was this huge debate in the legal community for about a decade about what to do with involuntary behaviors of all kinds, and under the Eighth Amendment and otherwise. And more than any other person, perhaps ironically or surprisingly, it's Justice Thurgood Marshall, great liberal lion of the period, who shuts down the effort to make involuntariness arguments as a basis for an Eighth Amendment challenge. And he says, we are, in so many words, in a case called Powell versus Texas from 1968, we're increasingly learning that so many things that humans do are in some sense involuntary. What's going to stop someone from coming in and saying, you can't bust me for murder, I suffered from a compulsion to kill? Or he said, we're going to have to let drunk drivers go free, because the alcoholic who's a chronic alcoholic and says, I can't stop my drinking, is going to make a Robinson-style argument. And basically, it would collapse the criminal law. Perhaps it's a bit of a legal fiction, but the criminal law relies pervasively on some kind of concept of free will. And we can't get into the business of deciding what is and isn't voluntary, except in the most extreme cases. So I think, and then just this past term, the Supreme Court reconsidered Robinson in the Grants Pass case, where people who lack homes were sleeping outside, and that was made criminal. And the question was, could they basically get protection from Robinson because there's nowhere, it's involuntary that they have to sleep outside lacking homes, and the court shut that down pretty definitively. So, which is just to say, I find hyperbolic a lot of these claims you heard from the courts then and now about just how impossible it is to distinguish involuntary from voluntary behaviors for these purposes. I think Courts could and should do more of that. But it gets them into difficult questions about addiction science and neurochemistry that they've often said they don't feel competent to handle. I think also there's a concern just about their workload that you saw play out in the early 70s. They realized every single defendant is going to come into court if we open up this door and claim that what they did was in some sense involuntary. And we're going to have expert witnesses galore talking about just how addicted is this person, what's the nature of their addiction, and we don't want to get into that. And so for reasons of kind of self-preservation and judicial economy, as well as kind of anti-crime, anti-drug reactionary sentiment that was building, you get a kind of liberal conservative coalition shutting down those arguments that have remained shut at the federal level for now 50 odd years. Sorry, it's a long answer, but it's a great question.
Can you reach?
Hello, thank you so much for the talk and for the interesting discussion. I was hoping to hear a little bit more about how much you think the constitutional argument for a right to drug use depends on autonomy and a kind of like a negative freedom of the kind that Professor Gersen alluded to, and how much of it depends on another thing that was brought up pretty frequently, which is the potential value of drug use. So like a welfarist argument rather than a libertarian one. Well, of course you could have both, but I think it might matter which one we think is most important. At least, here's a sort of like a particular thing that I'm hoping to hear more about, which is, well, that there might be vices that can be good for some people. There might be some that cannot, right? My home country, Brazil, is experiencing, I think, like a sports betting problem right now. I feel bad about it, and I have instincts that it should be regulated, but at the same time, maybe the fact that I've come to this talk is evidence that I have different thoughts on drugs. And I struggle to conciliate these two things, and I'm wondering sort of like you've thought about this issue far more than I have, what you have to say about it.
That's great. In Brazil, as you may know, the Supreme Court just issued this cannabis ruling, effectively decriminalizing it on autonomy grounds. It's in every court abroad, constitutional court abroad I know of, that has found any kind of drug right, it has been on an autonomy rationale. Perhaps because that's a more natural way to think of the rights claim than the consequentialist argument. Perhaps because the consequentialist arguments are very hard. They vary so much by substance, by context, that it's hard to say something general about the welfarist impacts of many drugs. I think for purposes of adjudication, at least, the autonomy arguments end up being cleaner. On gambling, I struggle with this too. I think my honest instincts are that there's much less social value, it seems to me, created, I think is where you were going, with online sports gambling or what have you, than drugs. Of course, drugs can also have profound destructive harms for many users. Let me give an example that was litigated in the 1970s. Riding off the coattails of the drug cases, a bunch of litigants came in and said, I should also be allowed to ride my motorcycle without a helmet because there too, if anyone's going to be harmed by that behavior, it's me. Like with drug use, third-party harms are pretty remote under Mill's harm principle or something. And courts really struggled with the riding a motorcycle without a helmet line of cases. It was like a robust line of cases in the 70s, and actually divided on that issue and ultimately cut against it. I felt like the courts lacked the language to say the most important point differentiating those cases, which is maybe some people get some kind of aesthetic benefit from riding a motorcycle without a helmet, but it's modest compared to what people say. Some people say they experience from drugs, which.
Have you ever ridden a motorcycle?
I've never done it, so yeah.
So I'm
maybe
here to say it's not just.
It's a high.
I think it's debatable. I wouldn't be so quick to be like, oh, it's not. It's really not very significant.
Okay, that's. I guess I think as this dialogue reflects, it's really hard to make so many of the benefits and harms people receive from these behaviors are idiosyncratic. It's hard to talk
And don't get me started on sports gambling.
Yeah. Are there benefits, in any event, I guess I think at a minimum, this could be handled in a regulatory calculus where you're doing, the language of which is CBA, and you can look at not only risk of addiction and monetary harms and physical harms, but also the subjective pleasures that people say they experience from a practice, which I think if you talk to gambling users would be modest as compared to what you'd get from the ecstasy using couple who says it, saved their marriage, and many, many other such accounts across drugs. I'm more agnostic or wary of courts engaging in that kind of analysis. But anyway, so I think there are in fact differences in the kinds of in the amount and nature of hedonic benefits thrown off by different vices, and it's that shouldn't be denied. But I'm not sure courts are the right place to engage in that analysis.
It reminds me of a line from your book where you say that lawyers are more Apollonian than Dionysian. So it's just kind of a
100%.
disconnect.
Yeah.
One more, but even within the world of drugs, this gets complicated because you could also ask which substances throw off better welfarist or deontological benefits than others. And there's a fierce debate within the kind of drug literature about whether that is a valid enterprise or not. So Carl Hart is a very prominent drug researcher at Columbia, where I am in the psychiatry department, who is strenuously opposed to any effort to create a normative hierarchy among drugs and say these drugs are, elicit more profound pleasures or are, than others, and therefore should get some better legal treatment. And he says that's an invitation to racialized thinking about which drugs are more or less valuable than others. It's an invitation to subjectivity and arbitrariness, and so better to avoid going there at all. I don't go as far as he goes, but just to say, even within the world of drug regulation, I think it's a difficult question whether and how you make these judgments.
Well, we're at time. I highly want to recommend this book. It's very readable. It really hits all of the famous constitutional law cases that you learn about. So it's great for lawyers, law students, anyone who wants to see the interconnections between constitutional law and drug policy. So you've done a great job of weaving them together. And great historical moments that a lot of people don't know about, like the Schaefer Commission and the Nixon HEW Committee on Psychedelics. These interesting historical events. So please join me in thanking Professor Pozen and Professor Gersen for joining us.
Thank you. Thank you.